Hello, my name is Brian Craig, and this is a presentation about end user license agreements entitled Read the Fine Print, Common Clauses in Software Agreements. Now, what is a software licensing agreement? A software license agreement is also called an end user license agreement, or just known as a EULA. Other terms might include a terms of use agreement, or TOU, or a software license agreement, or just a user agreement. These are agreements that govern the relationship between the end user and the software company. And there may also be a third party involved with these contracts. And an end user license agreement gives the user the right to use a particular software or application in some manner. So if you download some app from the App Store and you use that app, there's probably a terms of use agreement associated with that app. Now, there are a variety of different clauses that we find in these terms of use agreements. Common clauses include a license grant, limitations on use. So, for example, maybe a certain number of devices or a certain number of users. Intellectual property rights. Software is protected under copyright law. So, there's probably going to be a clause for maintaining those intellectual property rights. Limitation of liability. This is really big. A company will often want to limit its potential liability. A warranty disclaimer. A software company will also include a disclaimer that no express warranty is given. Governing law. This is a clause in the contract that says if there's a dispute between the user and the software company of which state law governs. And there are differences between different state laws. For example, the statute of limitations for breach of contract in Wyoming is 10 years versus a lot of other states, it's 5 or 6 years. That 5 years can make a big difference, whether the case will go forward or be dismissed. So if the company is based in a particular state, then the software company will often want to have that state law govern the terms of any dispute under the contract. For example, if the company is based in California, then the contract might state that California state law governs the contract. A forum selection clause. This is another clause similar to a governing law provision, but basically states that if there is a dispute and it goes to litigation, what court, what county will decide the case. So if the company is based in Salt Lake City, Utah, then maybe Salt Lake County, Utah will be the forum selection clause. For example, eBay has a forum selection clause that any litigation would take place in Salt Lake County, Utah. Support and maintenance terms. This is another clause in a contract of what support the company is going to provide. Termination clause. How do we end these contracts? And that will be stated in the termination clause. Usually either party can give notice for termination. Arbitration clause. This is an opt-out of litigation. This is really common in a lot of contracts. And some people think that these are unfair, but an arbitration clause is a very common clause we find in a lot of these software license agreements. Now, is a software license agreement valid? As a general rule, yes. EULAs are generally upheld by courts. There was a court decision in 2002 against Verizon Communications where the court held that a contract is no less a contract simply because it is entered into via a computer. And a number of courts have also cited that opinion in that quote. In this case, there was no unconscionability in the agreement by simply clicking an online button. So a lot of times you'll see a contract that says, I agree, and you click, I agree. In a more recent case, an arbitration clause was also found valid. There was a case against a video game company where a mother was claiming that her son was addicted to video games. The case was in the Western District of Missouri, decided in 2025. In this case, the court upheld an arbitration clause in the video game developer's online terms of use in terms of service and an end user license agreement. And the court found that the arbitration clauses were not unconscionable, basically upheld the validity of those arbitration clauses. So instead of going to litigation, we'll go to arbitration. A neutral third party hears evidence and actually issues a decision. The court held that the arbitration clauses were not hidden in small print. The terms were reasonably understandable. The terms of service and end user agreement had prominent capitalized notices to advise readers of the arbitration clauses, and the user agreement had an opt-out provision. So in this case, the court upheld the validity of that arbitration clause. And a lot of times those clauses are upheld. In some cases, the court may find that no, maybe if it was in small print and it was not reasonably understandable, then the court may find that the arbitration clause is invalid and unconscionable. Again, facts and circumstances of each case vary. That's just a short overview of end user license agreements for software. If you have any questions, please let us know. Thanks so much.